On January 2026, in the 260th Criminal District Court of Jefferson County, Texas, defendant Jasmine Holloway appeared before the court to resolve a Class A misdemeanor charge of resisting arrest, search, or transportation. The incident, which occurred on November 13, 2025, brought Holloway into the criminal justice system facing potential jail time and fines. What unfolds demonstrates how plea bargaining works in practice and why understanding your constitutional rights during this critical phase can mean the difference between prolonged incarceration and immediate release.
Ms. Holloway, is that your full name?
Yes,
Ms. Holloway, would you please raise your right hand? Ms. Holloway, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Ms. Holloway, you may put your hand down. How are you doing, Ms. Holloway? You okay? That's good. Now, Ms. Holloway, you're represented in your case by your attorney, Nathan Reynolds, and Attorney Reynolds. How are you doing?
Doing well, Judge, thank you.
You're welcome. Mr. Reynolds, do you waive a record in Ms. Holloway's case? Ms. Holloway, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jasmine Holloway, on or about November 13th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, or transportation. Ms. Holloway, do you understand what you've been charged with?
Yeah.
To this charge, Ms. Holloway, how do you plead? Guilty, not guilty, and no contest?
Yep.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
The judge conducted a plea colloquy with Jasmine Holloway, formally accepting her guilty plea to resisting arrest while verifying she understood the charge and was entering her plea voluntarily. Under Article 26.13 of the Texas Code of Criminal Procedure, a trial court must admonish a defendant before accepting a guilty plea by ensuring they understand the nature of the charge and the range of punishment, and that the plea is voluntary and not the result of force, threats, or promises, apart from the plea agreement itself. The Supreme Court reinforced this constitutional foundation in Boykin v. Alabama, 1969, holding that a guilty plea waives three fundamental constitutional rights: the privilege against self-incrimination, the right to trial by jury, and the right to confront one's accusers, making the trial judge's duty to confirm the defendant's knowing, intelligent, and voluntary waiver essential to due process. Here, the judge methodically follows Texas procedure by first establishing Holloway's identity under oath, confirming her legal representation, and then walking through the specific charge from the information filed by the district attorney. The judge's three critical questions, whether she pleads guilty, whether it's freely and voluntarily given, and whether she's pleading guilty because she is in fact guilty, directly implement Boykin's requirements. This on-record questioning creates a appellate record demonstrating Holloway's waiver was valid, protecting both the defendant's rights and the finality of the conviction. Without this procedural safeguard, defendants could later claim they didn't understand what they were giving up or were coerced into pleading, potentially overturning convictions years later and undermining public confidence in the justice system. The plea colloquy serves as the primary defense against involuntary pleas and ensures defendants make informed decisions about their constitutional rights.
Ms. Holloway, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, Ms. Holloway, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
Yeah.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yeah.
And on this document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yeah.
Is this your signature on the line that's titled Defendant?
Yeah.
At the top of this document, there are two boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Ms. Holloway, I also have before me on paper a document that is titled Discovery Certification. Do you recognize this document?
Here.
And is this your signature on the line inside the defendant?
The judge verified Holloway's signature on multiple plea documents, including the critical waiver of her right to appeal, ensuring she understood she was permanently giving up appellate review as part of her plea agreement. Article 44.02 of the Texas Code of Criminal Procedure establishes that a defendant may appeal only from a final judgment in a criminal case. But subsection B explicitly provides that a defendant who pleads guilty or nolo contendere in accordance with a plea bargain agreement has no right to appeal except under limited circumstances involving jurisdictional defects or violations of constitutional rights that are raised by written motion filed before trial. The Texas Court of Criminal Appeals clarified in Deckard v. State, 2008, that appellate waivers in plea agreements are enforceable when the record reflects the defendant's knowing and voluntary relinquishment of the right to appeal, emphasizing that defendants may bargain away appellate rights just as they bargain away trial rights. The judge's detailed questioning about the trial court certification of defendant's right of appeal document, specifically highlighting both checked boxes indicating this is a plea bargain case with no appeal rights and her personal waiver of any appeal, creates the record Deckard requires. By confirming Holloway recognizes her signature and understands she's giving up her right to appeal, the court ensures the waiver passes constitutional muster. The discovery certification, also signed by Holloway, demonstrates she received and reviewed the state's evidence before making this irrevocable decision. Appeal waivers are among the most consequential and least understood provisions in plea agreements. Defendants who later discover legal errors, ineffective assistance, or even actual innocence often find courthouse doors permanently closed because they waived appeal rights without fully grasping the implications. Courts must take special care to ensure these waivers are knowing and voluntary, not buried in fine print or glossed over in rushed proceedings.
Ms. Holloway, before you signed and initialed these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? Ms. Holloway, are you a citizen of the United States?
Yes.
Still for 6-1.
Any objections to State's Exhibit number 1?
No objection, states one.
No objection, State's Exhibit number 1 will be admitted. Mr. Reynolds, you advised in counsel, Ms. Holloway, is there any evidence that she is currently mentally incompetent to stand trial?
None to my knowledge.
And Ms. Holloway, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with this representation? Has he provided full, effective, and competent legal representation?
Yes.
Ms. Holloway, I will accept of no contest. I will find that you are mentally competent to stand trial. I will find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement in this case is to 95 days time served, court call, Saxon retired.
The judge confirmed Holloway's attorney reviewed all documents with her, found her mentally competent to proceed, accepted her guilty plea, and then moved to the negotiated plea agreement. 90 days time served with court costs retired. Under Article 115 of the Texas Code of Criminal Procedure, a court may not accept a guilty plea without first determining that the plea is supported by evidence showing the defendant's guilt, though this requirement is satisfied when the defendant voluntarily admits guilt on the record. The Supreme Court's decision in North Carolina v. Alford, 1970, permits guilty pleas even when defendants maintain innocence, so-called Alford pleas, provided the court finds a factual basis for the plea and the defendant intelligently concludes it's in their interest to plead guilty. Meanwhile, Article 42.03 governs the calculation of time served, requiring courts to credit defendants for all time spent in confinement pending trial and sentencing. Here, the judge explicitly finds sufficient evidence to find you guilty beyond a reasonable doubt based on Holloway's in-court admissions and the filed information, satisfying Article 15's evidentiary requirement. The plea to time served represents a classic prosecutorial concession. Holloway receives immediate release rather than additional incarceration, while the state secures a conviction without trial costs. The court costs taxed and retired provision reflects the practical reality that her 95 days of pretrial detention exceeds the agreed 90-day sentence. effectively converting jail time into payment of statutory court costs under Texas Government Code Section 51.921. Time-served plea bargains resolve a significant percentage of misdemeanor cases, allowing defendants to avoid extended incarceration while giving prosecutors conviction statistics. However, defendants must understand that the conviction itself, regardless of immediate release, creates a permanent criminal record with collateral consequences including employment barriers, housing restrictions, and potential immigration consequences that far outlast the jail sentence.
Ms. Holloway, the state is offering that you serve 95 days in Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail in this case because you've already served 95 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That simply means that the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Holloway, do you understand the state's offer?
Yes.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Holloway, I'll follow the plea bargaining agreement that you have entered into the state. Ms. Holloway, you're gonna stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day. And you'll be free to follow the bailiff. And Mr. Reynolds, you're free to go
Thank
and you have a blessed day. Court will be in recess. Okay, the person that's on Zoom that has Christopher's in.
Jasmine Holloway's case concluded with the court accepting her guilty plea and imposing the negotiated sentence. 90 days incarceration with credit for 95 days already served, resulting in her immediate release. The court costs were taxed and retired, meaning no financial obligation remains. Holloway walked out of the Jefferson County Courthouse a convicted person, but a free one, her 95 days of pretrial detention having satisfied both her criminal sentence and associated court fees. This case illustrates the central paradox of American criminal justice. The overwhelming majority of convictions result not from trials, but from negotiated pleas like Holloway's. The constitutional protections we associate with courtroom drama, jury trials, confrontation of witnesses, proof beyond reasonable doubt, are routinely waived in exchanges for certainty and leniency. Holloway's case demonstrates this system's efficiency. A single hearing resolved what might have consumed days of trial preparation, jury selection, testimony, and deliberation. Yet efficiency carries costs. Defendants like Holloway may accept pleas without fully appreciating collateral consequences or without knowing whether viable defenses existed. The judge's careful colloquy, while procedurally proper, cannot ensure genuine comprehension of rights being surrendered. For viewers, this case underscores why legal representation matters at every stage. Attorney Reynolds's negotiation of time served transformed potential additional incarceration into immediate freedom. It also reveals how pre-trial detention shapes justice. Holloway's 95 days in jail, often experienced by defendants who cannot afford bail, became her sentence rather than merely a temporary condition. The next time you consider the criminal justice system, remember, what happens in plea hearings like this one, repeated thousands of times daily across American courthouses, shapes far more lives than any trial ever could. If you or someone you know faces criminal charges, consult a qualified attorney before making any decisions about plea offers. The choices made in minutes during a plea hearing can reverberate for decades. For those interested in learning more, explore your state's code of criminal procedure and study how plea bargaining has evolved from an occasional practice to the dominant method of case resolution in American courts.